Yes, Mr. Good.
Thank you. Thank you so much. Just to remind ourselves, the Upper Tribunal allowed the Revenue's appeal on what we called ground one, and that's having looked at 149 and 150. That's recorded at 152, page 108 of the bundle, and that's relevant because looking at the deductibility issue, remember I showed you paragraph 62 and 63 saying, well, it's all murky as to what actually the FTT did with the deductibility issue. You'll see it paragraph 163 on page 110. (163) and 164, remember I said the deductibility only becomes live if it's not a distribution. Now this is where if all we had was this original decision, I say this respectfully, it's not clear. Anyway, it's clear that deductibility is a live issue. They say that in 164. And they go on to say, put short at 169, paragraph 170, as my Lord Justice Singh pointed out, and at 171, that, of course, these contributions, and that's what we're talking about, are not deductible. Why? Because at 169 they were to empty MDPL of profits. Judge Morgan's analysis was wrong. This is 170 because she was dealing with the hypothesis it was earnings. That's exactly the point that my Lord was making. And then 171 going back to this notion that it was all to empty the company of a profit, just because they're taxed under Part 7A doesn't make them deductible. That's 171. And that's my point. Because I'd given the Upper Tribunal, and I haven't given it to this court because this court is well aware of it. Cases like Strong and Woodyfield to say that wholly and exclusively deductible means for the purpose of earning profits. Here, what you had was the profits. There had already been earned. The expenses earning those profits had been incurred. And I showed you paragraph 161 of strategic branding. And just for completeness, at 161(3) of strategic branding, what Judge Zaman said is, well, look, first, I'm not following Judge Morgan's analysis in Marlborough because she was proceeding on the basis that she was looking at earnings, and Part 7 is different. At 161(3, she says, and I've made findings of fact here. Now, the reason that's relevant is that if you recollect what Judge Morgan did at paragraph 159 of the FTT decision in this case, she simply said, because I'm assuming these are earnings, they are deductible. That's what she did. So it was an inference from, as it were, a counterfactual assumption. And then the Upper Tribunal at paragraphs 175 and 176 on page 112 remake the FTT's decision on both Part 7A and deductibility. Now, if we stop there, and that's all we had, the question, that question's still there, that if Marlborough is right, and Judge Morgan was right, that there is a distribution, either because it's a loan or it's a contribution. The Upper Tribunal didn't in terms deal with that. We couldn't see that. the deductibility issue only arises if there's no distribution. That's true. And and that was one question. A separate question was one actually that was touched on in an exchange between my Lord Justice Singh and Mr. Firth yesterday, which is when the Upper Tribunal slid between direct or close, or strong and close, and the court explored with Mr. Firth, well, where did all that come from? I can show you exactly where it comes from. If you look at divider 10, this is a supplemental decision. This was in response to a complaint by Marlborough that the UT had applied a test that nobody had asked for. And paragraph 35, page 127, they're explaining themselves, saying, well, we drew all sorts of propositions from London Luton.
I'm sorry, which paragraph?
35, my lord.
Let me just get that. Yes, thank you very much.
And that's where these words come from. Strong or direct or close. We're just saying it could be any one of those. I disagree, but all I'm saying is that exchange has been had. Then at paragraph 67, please, on page 134.
I'm so sorry. So what the Upper Tribunal says is they all mean the same thing. They didn't come out of the blue, and they were the extraction from London Luton. So that's the explanation that they give, rightly or wrongly.
Exactly right, my lady. Please may I show you paragraph 67 on page 134. And this is all in response to Marlborough's complaint that this is a new test. The Upper Tribunal shouldn't have advanced it, shouldn't have applied it. And all I take from paragraph 67 is what they say in paragraph 150, that it was a sole director, it was his business. That was all understood by Marlborough. That's what they're saying there. And then, because we were still in the dark about this whole question of, well, distribution, what distribution? What have you decided? That's why the Upper Tribunal's decision on refusing us permission to appeal on Rangers, that's why this is actually illuminating. There's an unagreed bundle, and it's the one document that we all agree we can look at now, document 2. This is, does the court have it?
Hold on a minute. I must have it electronically, do I?
I also have an idea.
Bear with me just 1 second. I'd rather do it electronically.
I got confused because on the spine it says HMRC's agreed bundle.
What is it? Sorry.
That's the one I think you're referring to. Is it just, well, which tab is it in there?
Tab 2.
Tab 2.
And it starts on page 10, if that helps. Thank you very much.
Yes. Decision on application for permission to appeal. Exactly.
Because we wanted to appeal on Rangers, they say no. And we'd appealed on 3 grounds. 1, Edwards and Bairstow. 2, there was no reasoning. They said, forget about all that. Ground 3, starting at paragraph 16,
Yes.
Because our complaint there had been, look, in finding that the payment into the trust was not earnings, you also seemed to be saying in the course of your decision that Judge Morgan was right to call these payments in respect of shares. You seem to be saying that. That's what we say. And if that's true, the question of deduction doesn't arise. But we think that's a good ground for us to be able to challenge on. They say, well, to this, and what's more, given that they wanted a CT deduction, that's all relevant to the question whether there was distribution or not. We're not saying it's conclusive, but we need to know. And they say, well, that's all wrong. And it's paragraph 17. At no point in the decision does the tribunal state that a distribution can be a deductible expense. A distribution clearly cannot be so treated. Well, we all agree with that. The decision held that the FTT's conclusion that the relevant payments were not taxable as general earnings under section 62 contained no error of law. Well, if the point there is simply that it's not range as general type earnings, that's what we decided.
Mm-hmm.
Instead, the tribunal concluded that payments were taxable as employment income under Part 7A, so they mean the Upper Tribunal there. And then it's the next bit. This precludes the payments also being taxable as distributions under the principle set out at 72 of the decision. The paragraph 72 is all to do with the schedules are mutually exclusive. If you want, I'll show you it. If you look at
Just before you leave the reasoning, is that sentence, this precludes the payments also being taxable as distributions, is that accurate or inaccurate?
It is, if you're asking on the deductibility issue, if the payments are not distributions, that kills the CT deduction point, issue 5. Just does.
Yeah, so you agree with that?
Well, yes, that's common ground. If something is distribution, it can't give rise to a deductible expense. That's I absolutely agree with that. What I don't agree with, without more explanation, is, and without the explanation I've given this court, that if the loan is taxable, the loan mind, under Part 7A, why that means the contribution can't be a distribution. I don't understand that. If the question is, if the loan is the distribution, and it's also taxable under Part 7A, we've got the priority rule.
We know where we are.
Yeah.
We've got a piece of statute that tells us what to do.
Exactly. And my complaint was simply, I was at sea in trying to understand when the FTT and the UT talked about distributions, and the FTT in particular, what did they mean? Did they mean the loan or the contribution? Now, the reason I'm showing you this, and I don't want to dwell on it because I please do not underestimate how little I care whether there's a distribution in this case. But to the extent that this court needs to grapple with the point, was the contribution distribution, there the Upper Tribunal is saying, we have held the answer is no, there has not been a distribution on the contribution by MDPL to the trust. If you just look at our decision, can't you see that we've had to deal with wholly and exclusively? That's one point. And what's more, the tax on Part 7A precludes what being a distribution? The tax on the Part 7A charge is on the loan. So I'm saying this respectfully. Respectfully, this paragraph's a mess. You've got my point. I don't think there is a distribution, either on the contribution because it was not connected to shares, or on the loan because why would there be? But if there is, I don't care. but at least so far as the Upper Tribunal is concerned, it thinks it's found that the contribution, there is no distribution. At least that's what it says. And what's the relevance of that? Because I keep saying I don't care. The double tax point on the contribution being taxable in Dr. Thomas's hands drops away. I don't want to take anything more from these three decisions of the Upper Tribunal. I've got nothing to say about them except one, the supplemental decision, which confirms that there was no procedural unfairness, explains why they used all these different terms like close or direct, all that, they all mean the same thing. Two, everybody knows that at this point they make it one, the UT, that it was Dr. Thomas's business and he was the sole director. That was always clear to Marlborough. And then three, they don't think there's a distribution. I can't take more than that. I've got nothing more to say about these decisions on this point than that. But the Upper Tribunal in terms thinks there's no distribution.
I'm sorry, I didn't catch that.
The Upper Tribunal in terms thinks that there is no distribution. That's what it thinks it decided. So if I could map what I've been saying onto the 5 grounds of appeal. Ground 1, the UT erred in law. Well, what I've been saying is that the FTT erred in law, see paragraph 137 on part 7A. The UT erred in law in the sense of applying insofar as this is a question of law, a close and direct connection rather than a broad connection. For all the reasons we've been exploring this morning, the short point is one for this court to decide, which is simply was the loan in connection with the directorship. They looked at in connection with, they applied in connection with. And looking at 149 and 150, they relied on certain facts and came to an answer.
So you say they got the answer right, but they applied a test that was a little bit
Narrower than it ought to be, or
just
well,
not the right test.
exactly.
Let's go away from narrow and broad. Maybe decide
Of course.
that's the right way of going about it.
Of course.
But you say they were right in holding that the FTT had fallen into error.
Yes.
And in particular, they were right to say the FTT was wrong to import a causation test.
Yes, and let me be precise in what I'm saying about that. I say the FTT went wrong in law because they applied the identical test to that of earnings, and that's what everybody else thinks. I take that back, not everybody else, Judge Zaman thinks.
Yes.
The UT said they didn't apply the identical test, but they still applied the wrong test.
Yes.
So yes, that's how I'd like to put it, please. 2. This is ground 2. The UT erred in whether the connection, if there is one, was displaced. Well, displacement doesn't come into it. There's one arrangement, one scheme. Where the contribution was made, they wanted a CT deduction, they wanted a tax-free loan. This contribution tried to do both. There's no question of, as it were, a connection which exists being or needing to be displaced. There's nothing to displace it.
That word displace, I think, but correct me if I'm wrong, came from this court's judgment in the Barclays case?
Yes, it's when my Lady Justice Arden, as she was talking about when a connection like going to a Christmas party, which is a connection in a way of being an employee, is displaced by something else, something other, which is winning the raffle.
Yes. But the difficulty may be, as I was suggesting yesterday, that one should never read the words of a court's judgment as if they were the words of a statute.
I respectfully agree. And there's no part of my case that you should.
Right.
I haven't detected I've said that at all. If you think I have, then of course let me know and I'll take it back. But I clearly a judgment isn't a statute. And there's no part of Lady Justice Arden's decision which I'm taking and as it were lifting and reading that across to this case. I'm not doing that.
Right. So that's ground 2.
3, the UT failed to explain why this strong and direct test applied in favour of the revenue. And about that, I just say, paragraph 149 and 150 do the job. You've had my submissions. Four, the UT didn't explain how it was that this arrangement is a means of providing. I take the short, but how this arrangement is concerned or a means of providing or concerned in the provision of loans with a connection to the employment. And I've gone to great lengths to say, well, of course it was. It's 149 and 150 again. On 5, this wholly exclusively, you've got my point. 1, there's no pleaded business purpose other than the purposes in the resolution which weren't true. 2, there's duality because the contribution was to fund a tax-free loan to Dr. Thomas as well as trying to get a tax reduction. Neither of those are business purposes. 3, the mere fact that, well, I say mere, the fact that Part 7A taxes that loan has got nothing to say about whether that contribution was an expense trying to generate profits.
Sorry, just say that last point again, I missed that.
The fact that Dr. Thomas is taxed on the loan has got nothing to say. It's irrelevant to the question whether that expense was an expense incurred by Marlborough to generate profits.
Is that the point that was made by the Upper Tribunal in the final sentence of paragraph 170?
I think so.
Yeah, that's how I understood it.
And I've already said, looking at the FTT decision in this case at paragraph 159, when the discussion started, Judge Morgan was looking at tax under either general earnings or Part 7A, having decided that neither applied, but it's clear, because she uses the word earnings in 159, that she thinks they're the same. But it was on that counterfactual hypothesis, she says they are deductible. It's an inference from this counterfactual hypothesis. She doesn't say in the light of the following specific facts. She thinks it somehow logically follows. So that's why I say it was wrong to suggest that this was a finding of fact by Judge Morgan, because what she was responding to in saying that was me saying, it's all tax avoidance. And what she said is, well, oh no, if it's taxable as earnings.
It's earnings, it's not taxable.
Yeah,
But even suppose, Mr. Ghosh, even suppose it had not been on a counterfactual basis, I think your submission would still be not a finding of fact, because it's, in the Investec terms, it's a categorization of facts as found, and that's a question of law.
Exactly right. I'm stuck with the findings of fact she did make.
Yes.
But otherwise, what your lordship says to me is exactly right.
Yeah, so the question whether expenditure was wholly and exclusively for the purposes of the trade, you say, is a question that the Upper Tribunal not only was entitled to, but had to form its own view about. Just as this court, I think you say, we're not stuck with the Upper Tribunal's view. Is that right?
Yes, I do say that.
We don't ask ourselves, were they entitled to reach the view they did in paragraphs 169 to 171? Have I got this right? That we should ask ourselves the question, is the conclusion correct?
So long as we're not disturbing the findings of fact that were
Of
actually
course.
made. And that's exactly what my Lady Rose said in that paragraph that you'll recollect that I took you to.
Yeah. And this is pretty well-trodden territory, because as I said, in the last century of law reports show many cases in which the House of Lords has formed its own view.
Reversing the lower courts.
Exactly.
So you have my submission,
Yeah.
and I say we win for the reasons I've given. With the court's permission, please can I just adopt what I say about section 1290 and the deferral of deductions? That's all to do with. It's if and only if I'm wrong and wholly exclusively, so they do get a deduction. That deduction is deferred until a payment comes out, which is taxable. And it doesn't actually arise in this case, because if I'm right about wholly exclusively, that anti-avoidance provision doesn't apply. Even if I'm wrong, that there's the contribution is wholly and exclusively. If I'm right that Part 7A applies to taxed alone, then they get the deduction straight away. And if, and it's only if, because of Marlborough's concession, what they say is, if it's not taxable under Part 7A or general earnings, we know we don't get a deduction. So really what I'm saying in a very long-winded way is forget 1290, but I reserve my position if I ever have to look at it again. So I'm not dropping the point, I'm just saying it's vanishingly, there's a vanishingly small chance it's going to make any difference in this case. And if I could close. Oh, yes, yes. If I could just please address you on what the revenue say about disposing of this case. We say the FDT erred in law both in Part 7A and on the deductibility issue. That permitted the UT, the Upper Tribunal, to remake the decision on both those issues. On Part 7A, on tax, I think the numbers are agreed between the parties, but I can't be sure, so we'd be grateful for a decision in principle. It is open to this court to remake the Part 7A decision, and I'm not going to lie, a coherent summary of the relevant facts and how the in-connection test applies to those facts on the face of a single judgment, I think would benefit all of us. So I do invite the court, and it's been done before. This court has remade the decision without any hesitation in a case called BlackRock. It also remade the decision without any hesitation. I think it was my Lady versus Whipple in a case called Archer, where it was me. It's open to the court, and it, insofar as it gives us a single judgment with the relevant facts and the relevant decision remade in principle, that I, in my respectful submission, is helpful and useful. Similarly, on the deductibility issue, and on Part 7A, if you remember, I don't care about whether there's distribution or not. On the deductibility issue, I think the court will have to grapple with whether there's been a distribution and what it is, because if there is a distribution, there isn't a deduction. And I simply have no views on which one. The contribution, as I say, was disconnected to the shares. The loan, my submission that there was a disconnect between the loan and the shares was rejected. In my respectful submission, it would be again helpful for this court to make the decision on one of principle. Here, the numbers will have to be adjusted, so a decision in principle is in my respectful submission helpful. And in any event, there is one issue on deductibility, the accounting issue, which has been stayed. So we wouldn't want a final order. That's all I'm saying.
Is that stayed before the FTT?
Yeah. So, for completeness, I adopt everything I say in my skeleton. And if you just give me 1 minute, I'll check. There's nothing else I need to address you on. That is my reply.
Thank you very much. Yes, Mr. Firth.
Before I get into the substance of the reply, if I may respectfully say, my learned friend is inviting this court down a dangerous path with his submissions on Investec. There are findings of fact, there are questions of law, but between the two, there are evaluative conclusions. And it is extremely well established, and I'll show you the Upper Tribunal had no doubt about this, it wasn't in question at all, that when it comes to applying the law to the facts, that is an evaluative conclusion, and it is not to be interfered with simply because this court would take a different view. Instead, you apply essentially a Bairstow, Edwards and Bairstow type approach. And so when my learned friend suggests that he can transform the question of, well, was this in respect of shares into a question of law, simply by saying he accepts the underlying factual findings, that's with respect wrong. It's an evaluative conclusion. The Upper Tribunal treated it as such, rejected HMRC's appeal on every single basis, and what's more, Lord Justice Newey considered HMRC's appeal, again trying to challenge the evaluative conclusion, rejected it precisely because it was a challenge to an evaluative conclusion, and yet here we are again today, listening to exactly the same type of arguments. In my respectful submission, there is a clear distinction between a pure question of law, which of course this court considers for itself, and an evaluative conclusion. And on the latter, it's not for this court to simply substitute its view. If I may support that by showing you Upper Tribunal decision in the court bundle, its relevant paragraph is 89, sorry, page 89, paragraph 75. In our view, the FTT was faced with an evaluative judgment as to whether the payment by MDPL via the trust was from employment or in respect of its shareholding in MDPL. Essentially, this was an evaluative decision to be reached in light of all the relevant evidence. It is well established that this tribunal should be reluctant to interfere with this decision, of the FTT, which heard the evidence and considered the documentary evidence. You can see it goes on at 76 to talk about the Tribunals and Courts Act. 77 says we have a power to set aside if it took into account an irrelevant consideration or failed to take account of relevant considerations.
Yes.
And so on. I mean, this is very well trodden territory. HMRC routinely rely upon it when they succeed on an evaluative question. It's not a different test. in this court. My learned friend not pointed to any misunderstanding of the law. I don't think we've been shown a single case on the meaning of in respect of shares to suggest the tribunal didn't know what that means. The tribunal set out its conclusions, so it set out the law and reached a conclusion. So there is no error of law, and the challenge to the evaluative findings took place in the Upper Tribunal, and HMRC failed on every ground, and they failed to get permission, and so my submission is not open to HMRC to challenge that in this court.
This was said in the context of the general earnings point.
The decision that this was that because the way the first tier tribunal looked at the general earnings question was, well, we've got it's paragraph 128. We've got two competing submissions from the parties. Is it in respect of shares? Is it from employment? And if not, what is it in respect of? The only candidate is in respect of shares, which is what we submitted for, and it found that we were correct on that point.
Yeah.
And so that's why it's decided in that part of the decision that it is a firm finding in my submission, and there's no error of law in the even in this court. Mr. Ghosh hasn't pointed you to a decision and said, well, the first tier tribunal misunderstood what in respect of shares means. It clearly didn't.
That wasn't going to be my question. On the question of whether an expense is deductible because it's wholly and exclusively for the purposes of the trade.
Yes.
On your submission, is that a question of law or an evaluative question? But that's the point that Mr. Ghosh was relying on Investec for, I think.
Whether something is wholly and exclusively for the purpose of the trade involves an evaluation of the facts in light of the legal test.
Yeah, but do you accept what Investec appears to say, which is that is a question of law for an appellate court or tribunal to take its own view about?
Well, I wasn't aware we were going to deal with this issue. I would want to, if I have to commit to that, have a look into it. My instinct tells me it's an evaluative conclusion, but it does involve questions of law.
Well, you can certainly have time. If you want to have time to think about Investec,
yes,
you'll be given that time. But I mean, it's been referred to in submissions.
I see that now. But in relation to the in respect of shares point, what we've clearly seen, and I think that's the more relevant issue, given we heard many times about this, that certainly is an evaluative conclusion,
Yes.
and HMRC, with respect, failed to successfully challenge it and been refused permission on that exact issue.
On the wholly and exclusively test, to pick up my lord's point, I mean, we used to call these, didn't we, questions of mixed fact and law, which I personally find slightly easier because evaluation means different things to different people. But whether something is wholly and exclusively, a piece of expenditure is wholly and exclusively for the purpose of the trade, there's plainly legal elements in that. It's obviously got a legal aspect to it, which would normally make it amenable to review by a higher court.
Well, so that's why there's essentially three stages. The first is identify what the primary facts are. So what purposes did you actually have? The second is, well, what's the legal test? And the legal test only takes you so far in terms of there must be wholly and exclusively, must be a trade benefit, etc. And then comes the evaluative question. My lady doesn't like that term.
Well, I don't like it, but yeah.
But
Okay.
you've got the facts, you've got the law. Now you apply the law to the facts. And that is where the evaluation becomes in, because that's the point at which different tribunals could come to different conclusions on the same facts. And the reluctance is to discourage lots and lots of appeals, is to discourage appeals by saying, well, we're not going to interfere with that unless it has one of essentially the Edwards and Bairstow type ones, and you didn't take into account all the facts or something like that. But my lady's correct. There are
Isn't
questions
it
of
rather
law.
that it is amenable to appeal, but the higher court may exercise self-restraint in interfering with a decision that it thinks comes within a reasonable range of responses, of evaluating, applying that piece of law to those facts.
My lady, that's where it falls out essentially. So you've got essentially three options. You can say, well, they got the test wrong. Look at this authority as a matter of law. They got the legal test wrong. You can say, well, and this is obviously the high Edwards and Bairstow challenge, that finding of fact shouldn't have been made. And then in between that, as my lady says, you've got a similar type of question. Well, they've applied the law to the facts, unless they've gone wrong. And either of the first two stages, there's actually a presumption, I think the cases say, that they've they've stated the test correctly, then they've applied it correctly. There's a presumption. So yes, it's judicial restraint, and that's why you're looking for things like failure to take into account relevant considerations, or that line. But I don't want to commit on wholly exclusively, because depending on which area it is, there's cases saying it is or is not a question of law in certain situations, and I wouldn't want to commit myself without properly thinking about that. If I may, just while I'm dealing with the in respect of shares point, the Upper Tribunal refusal decision, which was shown in HMRC's additional supplemental bundle, if I could just ask you to reopen that, because I, with respect, do disagree with what is said about paragraph 17. Because Mr. Ghosh says, well, this is the Upper Tribunal saying they're not distributions. And that isn't what it says. It says they're not taxable as distributions, because applying the reasoning the Upper Tribunal refers to in 72, the PA holdings type reasoning, there's a charge that takes priority. That doesn't mean it isn't a distribution. That just means that another charge takes priority. So there's no finding, and nor could there have been. It would be inconsistent with the whole basis of the main decision to say, well, they're not distributions. You can see well, I've already shown you the Upper Tribunal considered that point in some detail and rejected the grounds.
That's the in respect of shares point.
Yes, yes, whether it's a distribution in respect of shares.
Yeah.
So, because Mr. Ghosh was suggesting, well, the Upper Tribunal's changed its mind and said, in fact, they're not distributions, belatedly accepting his argument that they were not in respect of shares. But we know that's not right, and we can read the whole decision if we want to find out why. With that introduction on the tests on appeal, turning now to the Part 7a question, our observation, our initial observation, would be the HMRC submission on what in connection with requires, or what type of analysis it requires, seemed to be somewhat unstable. When it was suggested to Mr. Ghosh that these were ordinary words and should simply be applied as such, it seemed that he agreed. But equally, when it was suggested that actually we need to give content to these words by reference to the purpose, context, and background, he equally agreed. Our submission is it's clear from the case law, and of course, London Luton is a decision of this court, applying a decision of the House of Lords, that it is a protean phrase to which content must be given by considering the context, background, and purpose. That is what happened in London Luton itself. As my Lady Justice Whipple explained during this morning's proceedings, in London Luton, the lower tribunals hadn't applied some other in connection with test, but they just applied the having to do with type test, and my Lady and Lady Justice Falk said, well, that's not right in this particular context for these particular reasons. And so you can have situations where it does have to do with, but actually that's not the right test, and we see London Luton as an example of that. So that means this court does have to look at the background, purpose, and context to try and understand what Parliament had in mind and give content to it. In terms of the background, it's common ground that the origin of this legislation was the perceived problem with general earnings charge not catching payments through intermediaries. It was very specifically that the involvement of an intermediary, a third party, somehow stopped the from employment or the by reason employment test being satisfied. What that means, as I said yesterday, is that it has nothing to do, on the face of it, in light of that background, with catching payments where employment's no part of the reason. I mean, it's possible we could end up there, but we're not doing so based on a steady, solid starting point where Parliament has identified any mischief in relation to that issue. There is no mischief that supports interpreting this as applying even where employment's no part of the reason. In terms of the purpose, well, I showed you the budget statements and the explanatory notes, and they repeatedly make clear So this is targeted at, directed at arrangements to reward employees through third parties. So we're left in no doubt, having read that, as to what the purpose is here. And again, it's possible that when we look at the wording of the legislation, we're compelled to the conclusion it goes beyond that, maybe far beyond that. But actually that's not the case here, because we've got a protean phrase, and we know what the purpose is, and it's a wholly intelligible purpose, and we can give effect to that. And Cobalt shows. There they looked at the Treasury press statement. Cobalt shows that's an entirely appropriate way of dealing with things, and here we've got the explanatory notes as well, making it clear. And what that means is that if HMRC are right, and this does catch payments where employment's no part of the purpose, we can't explain that in terms of the purpose, in terms of the purpose of the legislation. And to be clear, because there was, I think, a slight confusion at one point, my submission is not about there being no purpose in charging these payments to income tax. My point is there's no purpose in charging them to employment income tax. In particular, you've seen the distributions code already amply deals with distributions in respect of shares. What we're looking for, if we can find it, is some explanation, some intelligible reason why we can say, yes, well, Parliament may well have intended to catch payments where employment is no part of the reason, and this is it. We can't here. We've looked at the background, that tells us the problem is intermediaries. We've looked at the purpose, again, that tells us it's about rewarding, but through intermediaries. When we look at what HMRC's case is now, it is narrowed over the course of this litigation. Because now what is critical is who signed the resolution. Who signed a document. So their proposition to this court, so we're considering this in the sense that, let's even assume I'm wrong, and connection can go with beyond being part of the reason. Let's look now where HMRC seek to take this court, and they seek to say you should find a connection where, or based upon the person, or the identity of the person who signed a document. And go back to what we know about the interpretation of this phrase, the background, the context, the purpose. And I respectfully invite the court to ask itself what possible rational purpose can be imagined whereby Parliament intended the question of who signed the document to be critical, indeed determinative. Because that's what HMRC is saying. They're saying, well, look, there's a clear connection. It's very visible because look at who signed the document, Dr. Thomas. And that document funded the loan, he got the loan, and that's enough. And the only step in there that in any way is connected with the directorship is the signing of the document. There is no other tax charge I can think of that attaches critical significance, or indeed any significance, to the question of who signed the document on behalf of the company. That is mere mechanism. It's not substance. It draws an arbitrary distinction between the same situation based on the identity of who signed the resolution. So you can have a situation where the director who got the loan signed the resolution, that's court and HMRC's approach, and a situation where the director who signed the resolution was a different director. So not court, because there you don't have that supposedly very visible connection. And then we go to the context. We looked at the background and the purpose and the context. And our phrase is reward, recognition, or loan in connection with employment. And HMRC's case now boils down to the connection to directorship being through forming a single administrative act in the capacity as a director. That's it. So when you see that word, that concept employment at the end of our phrase, reward recognition loan in connection with employment. HMRC are taking that word, that concept, employment, and saying, well, a single administrative act performed by a director, that's what employment means. And we say that must be wrong. That cannot be what Parliament had in mind when it said employment. The employment, we say, plainly refers to the work done, the substance of the service provided to the company. That is the essence of what employment is, not signing a document, a single document as part of a scheme. And this we say is analogous to the reasoning in London Luton, because there the court looked at, well, what does the connection have to be with? Conversion. What's a conversion? It's a physical change in the building. Well, that helps us understand what type of connection we're looking at. Here, applying the same sort of thinking, what does the employment refer to? Does it refer to or include a single administrative act as part of a scheme, signing a document, or does it refer to, as I said, the substance of the service, the work done for the company? We say clearly the latter. And that's all the more so given that we're being told repeatedly to get to the essence of the matter. The essence of employment doesn't lie in a single director signing a single administrative document as part of the scheme. The essence of employment lies in the work you've done for the company. And indeed, HMRC's approach ends up almost being circular. They end up saying that the loan is in connection with employment because the administrative act providing the funds for the loan was taken by a director. So it's entirely self-contained. You've got an arrangement, and the link to employment is not outside of the arrangements, it's within the arrangement. It's the first step taken, or one of the steps taken, for the purpose of the arrangement. It's got nothing to do with the work, the service of the director actually running a business. Nothing to do with that. It's entirely contained within the scheme. You don't need to look outside the arrangement to satisfy Part 7A, which plainly cannot be what that test was trying to do. We've got the need for an arrangement. We've got the need for an employment. And then we've got the need for a connection between the rewards recognition loan and the employment. Is that intended to be entirely self-contained or potentially be satisfied on an entirely self-contained basis? We say no. And this argument has been rejected. It was rejected by the first tier tribunal, it was rejected by the upper tribunal, precisely because it lacks substance. It doesn't get to the essence. I showed it to you yesterday, but if I could just remind you of it, paragraph 119 of the upper tribunal decision, please, which is page 101 of the core bundle. So paragraph 119, Upper Tribunal says, the fact that the contributions were authorised by Dr. Thomas, acting as a director, cannot in our view impart the character of employment income to those payments. The company can only act by the agency of either directors or resolutions. As Mr. Firth observed, the question is not who decided, but why was the payment made. To suggest that a payment by a company which is authorised by its director imparts that payment with the character of employment income seems far-fetched. That would be a strange conclusion, which of itself suggests the proposition is incorrect. I appreciate that's in the context of general earnings, but the proposition there, accepted by the upper tribunal, that the question of who does not tell you about the character of the payment is wider than that. And it's plainly correct, particularly in a situation where we're being told to get to the essence of the matter. You've already seen, I don't think I need to take you back to it, but at 149, the upper tribunal returns to that point and makes it again. In my submission, you're when you're considering that part of the Upper Tribunal's reasoning, you should consider those paragraphs together, along obviously with my submissions to the point. That's a perfectly correct argument. As I said, I cannot think of any other situation in which it has been held or even suggested that who signed a particular document on behalf of the company is critical to determining whether there's a tax right. That is astonishing. And what that submission means is that even if this court were to say, well, no, part of the employment or part of the reason for the payment is not the right test, we've got to look at other things. HMRC have not identified before this court a sustainable basis for saying there is a connection, or it is in connection with. So that's a very important point. Even if you're not with me, I'll maintain my submissions and I'll continue to develop them. It doesn't follow that HMRC are right. Continuing with context, so bearing in mind our phrase, which we've seen too many times for me to need to take you to it: reward, recognition, or loan in connection with employment. It's an explicit part of HMRC's case now that a loan will be caught in circumstances where an outright payment would not. That was their explanation of Clipperton. My learned friend touched briefly on this during his submissions to try and explain why that's not a surprising conclusion. And this court will know that where an interpretation leads to absurd results, which has quite a wide meaning of just contrary to common sense or various other principles, then you should be slow to accept it. So my learned friend touched upon this to explain why in HMRC submission that's not a surprising conclusion. And the answer was, well, that's okay, because a loan is easier to make. With respect, that is no explanation. An individual receiving a loan that in reality they may or may well not have to repay is in the same position as a person receiving an outright payment, certainly not in a better position. Yet HMRC say Parliament intended to catch the person with an obligation to repay under Part 7A in circumstances where the person without an obligation to repay would not be caught. And in my submission, this directly engages the principle referred to in paragraph 75 of London Luton about treating taxpayers in a similar position in the same way, in the absence of good reason for not doing so. And we've heard HMRC's attempt at an explanation now. It doesn't come close. I mean, the idea that how easy it is or is not to make a loan as compared to an outright payment, which frankly is a matter of supposition from my learned friend, has no relevance to whether the recipient of a loan versus an outright payment should be taxed under Part 7A or not. It's just not a relevant consideration at all. It cannot explain or justify why Parliament would have intended to put them in different categories. And there's a further issue that arises out of this, because we're told to get to the essence of the matter. And in cases like this, we've got findings from the FTT, in our case, paragraph 46. There wasn't really an expectation that the loan would ever have to be repaid. So, in essence, was it a loan, wasn't a loan? I mean, on my submission, that shouldn't make any difference. But on HMRC's submission, it's critical, because a loan will be caught in circumstances where an outright payment wouldn't be. So if you can say, well, in essence, this was an outright payment, you're in a better position vis-a-vis Part 7A than if you say it's a loan. My submission, as you know, is that, well, we can look at reward, recognition, or loan together to try and get a sense of what Parliament meant by in connection with. And the sense we get in my submission is, well, it seems that employment has to be part of the reason And that's accepted by the looks of it in relation to reward and recognition. A reward in connection with employment must be part of the reason. Recognition in connection with employment must be part of the reason. Loan in connection with employment doesn't have to be part of the reason. Well, that's a very odd structure, odd outcome for the reasons I explained, and you should lean against that interpretation for the reasons set out in London Lucent paragraph 75. Continuing in the line of the essence of the matter, we have to test HMRC's interpretation and their application to the facts against that particular criterion. Because even if this court were to say, well, yes, it's broader than part of the reason, so it does look at other things, you still have to test, well, is that connection that HMRC have identified part of the essence? And that's where things get quite puzzling from our perspective, listening to HMRC's submissions, because in the context of making submissions in the charity example, Mr. Ghosh said, well, we need to look at here, what is the essence, the driver? And he said the essence and the driver for the charity is obviously not the employment. He said, as I've got a record, that who signed the resolution is a mere mechanic or mechanism. And our proposition is, well, true, but that's always true. It's always a matter of mere mechanism who signs a particular company document. It's a matter of happenstance whether there's one director or two directors. It cannot be the case that you can escape Part 7A by having Director A sign instead of Director B. That cannot be what Parliament intended. Certainly when it's talking about getting to the essence of the matter. So there is a real concern that HMRC submissions are an attempt to reduce the in connection with employment test to a sideshow, which can be, in many cases, satisfied by default, simply by the arrangements themselves, without, as I said, without looking outside the arrangement, without looking at actually what was the employment and seeing whether there's a connection with the actual work done. We can somehow satisfy Part 7A. Now, I've taken you through the background, context, and purpose. It has no support whatsoever. My learned friend couldn't even venture anything. I mean, that was a glaring silence throughout. Any offer as to why. So this court would have to accept that and say, well, we don't know why, but it's where it leads. 554F. Mr. Ghosh said, well, this applies to a customer who's an employee. No, it doesn't. Because in that situation, there's no relevant third party. It applies, where, as I suggested yesterday, where, for example, the employer makes an arrangement with the bank. And the bank's going to offer loans or whatever to the employees of the employer. And there's no difficulty to my case with that, because it's entirely conceivable that the in connection with test is satisfied there if the employer approaches the bank saying, will you offer my employees loans on particular terms or what have you, and that would be in connection with the employment. No qualms about that. So you can easily see how that could fall within Part 7A, and Parliament said, we're not going to catch that. But as HMRC now accepts, it's a very narrow exception. It doesn't help you identify the content of the in connection with test. And indeed, in the only case at a high level actually dealing with this issue, simply the meaning of in connection with, well, we saw Barclays, and there the connection was, the reason why you were selected was employment. That's exactly the type of connection we say, and Lady Justice Arden was very clear that she considered this a strong, very strong reason and unlikely to be displaced, and the other matters Mr. Peacock relied on were merely subsidiary, and in fact all of them were simply directed at trying to prove an alternative reason. Mr. Peacock was trying to prove well, the reason for this payment is not the employment, it's to replace the free tax benefit. Context. Mr. Ghosh says, well, you've got to understand there's a family of provisions in the employment income tax legislation, and this falls into one category rather than the other. I'm not really sure what we're supposed to make of that. It wasn't developed by reference to any references to legislation. What we do have is we have the general earnings charge, and then we have the benefits code. And then we have codes that deal with other specific instances. So, for example, Part 7, employment-related securities. That uses the by reason of employment test. But each of these codes, including, we'll come on to the termination payments code, has a background, has an explanation of why it's there. So the benefits code is there because, in a case called Tennant and Smith, the House of Lords held, well, if you give an employee a benefit in kind, the tax attaches to the convertible value of the benefit, not the full value. So now we have the benefits code which sorts that out. Part 7 is there with the employment-related securities code because in Abbott and Philbin, it was held that if you give an employee a security, the employment charge attaches at the point of giving the security to the employee, doesn't attach to the gain they may make by selling the security. So now we have the employment-related securities part. The termination payments part was to deal with the fact that a payment in respect of termination of employment was held not to be from employment because it arises on the occasion of the termination of employment. So every one of these parts has a story you can tell. And you can explain and understand what Parliament's doing and you can make sense of it. And that includes Part 7A. And when the House of Lords, Supreme Court was looking at Part 7, the Employment-Related Securities Code in UBS in 2016, the history was an important part of their consideration along the way to deciding, well, are these conditions the sort of conditions that Parliament had in mind? So it's always relevant to look at the history, and we know the history of Part 7A. The history is agreed. It's common ground what it was put in place to do, and HMRC say, well, actually, as luck would have it, it does a lot else beside, goes very far beyond any reasonably imaginable test for what connects them to employment. To deal with Section 401 itself, that helps. That helps the appellant, because you saw there, it says, and the tribunal's seen this in the context of the Mather case, but I'll just read it out. It's received directly or indirectly in consideration or in consequence of or otherwise in connection with. That is a triple-barrel test. We have express reference to directly or indirectly, and we have express reference to otherwise in connection with. You saw in Marthor, it's paragraph 64, by reference to the Court of Appeal in Morthy, that they focus on two things in particular in saying, well, this is a wide approach to catching things. First was the indirectly or directly, that was point 1. And point 2 was otherwise, the word otherwise before in connection with. We don't have that. So Parliament has to exercise a deliberate decision not to lift that phrase and place it into Part 7A. Instead, it's just said, well, it's not just said, it's said in connection with, and then emphasised repeatedly, get to the essence of the matter. That is a very different statutory context to Section 401. As I said, Section 401 has its own history as to why it's there, what it's trying to do. It'd be very dangerous to lift that and try and say, well, Part 7A had the same purpose. No support for that. So here, we just have in connection with, but it has to be part of the essence. It's a very different test. Parliament could have used the wider words, didn't. And even in relation to Section 401, it's clear that not just any connection will satisfy the test. For example, on the liquidation of a company, you've got a sole director shareholder, and there's a distribution in the winding up. Well, that is connected to the termination in one sense, because it's all part of winding up the company, finishing off the directorship, but nobody suggests that that payment, that distribution and winding up, is taxable as employment income, even though necessarily is associated with the termination of employment. So it's not an unlimited test. The limits, well, they can be considered in our case, but it just doesn't help us here, other than to say it's not our test. And so we do say our positive case is, having looked at all the materials, it's fair to say that Parliament must have intended this to apply where employment's at least part of the reason. But even if I'm wrong on that, and this court says, well, no, we can look at other things, HMRC don't come close to satisfying this court that there was an in connection with test here because of the way they put it. My other grounds, so grounds 2, 3, and 4, essentially depend upon or only arise if I lose on ground 1. So it's necessarily in a situation where you held that no, it doesn't have to be part of, the reason, employment doesn't have to be part of the reason. Then we're on to grounds 2, 3, and 4. And therefore we do have to consider whether the proposed connection, whether it be the upper tribunals or HMRCs, is part of the essence. We do have to consider whether it was what the arrangement was a means of or concerned with doing. And as I've submitted, that's a question of purpose. What's it trying to do? And on no view can you say, well, this scheme is trying to get loans to somebody who signed a resolution. That's not what it's trying to do. We've got the FDT's findings. It's what it's trying to do is provide a return on his investment of his shares. Mr. Kirsch repeatedly said, well, I accept that now. So when this court asks itself the question, what was this scheme a means of doing? What was it concerned to achieve? Answer, on the FDT's own findings, that HMRC accept providing a return on the investment to Dr. Thomas, not providing loans to somebody who signed a resolution. We turn then to the double taxation issue. This is a supporting issue. It's a long way from the main show, but it does help because you saw in Z3, 4, Z3, 5, 6, a deliberate attempt by Parliament to avoid double taxation. So for Mr. Gersh to turn up and say, well, I don't care if there's double taxation, well, you may not, but Parliament clearly did. And again, we can see the story. It's not difficult. The reason for the 2017 amendments was precisely because Parliament hadn't realised that there could be employment income on the way in because of they weren't even arguing the point for HMRC at the time. But then in 2015 they succeed in ranges in the Court of Session. And then in short order after that we have the legislation dealing with exactly that issue. Employment income on the way in, employment income on the way out. Well, we don't want both. And so you have a consistent theme of avoiding double taxation at every stage. So it really isn't right for HMRC to say, well, we don't care if there's double taxation. That's not appropriate. Now I'll say a bit more about those 2017 provisions in a moment. But just to deal with this point that in Z2 it says, well, if the relevant steps also are within the distribution charge, then Part 7A has priority. Well, the relevant step could well be a dividend because the third party could well be a company. And this is all focused on what the relevant step is. And Mr. Gersh makes quite a fuss as to, well, is the distribution the contribution, is the distribution the loan? Well, we can see at FTT 128. Don't mind turning that up. The FTT boils down the question. So this is where it sets out the question. Page 188 of the court bundle upward. The question is essentially, one, whether the contributions made by MDPL are to be regarded as remuneration or reward. The basis of that rule is the reason why MDPL made the contribution or a sufficiently substantial cause. or two, whether MDPL made the contributions for different reasons, such that they have a non-employment source, the only identifiable other source, or other reason being that they were made in respect of shareholding. And we know the answer that they came to in respect of shareholding. Now, Mr. Ghosh says, well, if it could be the loan that was the distribution, I don't really see that because the loan wasn't made by the company. How could it be a distribution by a company when it's made by a trust? And if what Mr. Ghosh is suggesting was maybe we could just take an overall realistic view of the facts here, well, that might well be appropriate. That's what happened in Clipperton. But then the relevant steps not being taken by a third party because you've looked at it overall. In a realistic view, this is just money going from the company to Dr. Thomas. There's no relevant step by a relevant third party there. So we do have this issue. Parliament didn't contemplate that the funding itself would be liable to tax, and it didn't provide for it. Rangers changed that because HMRC changed their argument in 2015. We know that. And that led directly to the 2017 changes. And contrary to what Mr. Ghosh says, they're not retrospective. They don't say this shall be treated as if it was always part of Part 7A. Instead, what they do is something slightly different. They say the legislation takes effect from 27th of April 2017. You can see this in the notes after the various provisions. So it takes effect from 27th of April 2017, but it applies from that date in relation to relevant steps taken from or since 2011.
Isn't that exactly what one would expect? Because the changes that we're concerned with in this appeal took effect in April 2011, as I understand.
Yes.
Yeah. And so isn't it as simple as this, that in 2017, Parliament took the view that it would not, as it normally does, enact legislation only prospectively from 2017, but also in respect of acts that took place between 2011 and 2017?
That's not, in my respectful submission, that's not retrospective legislation. That's attaching consequences in 2017, obviously by reference to things that may have happened in the past, which is not retrospective legislation. I'm sure HMRC in other contexts have vigorously argued that. What it's doing is saying that as of 2017, and if we perhaps can look at it, because you weren't shown the detail of it, it's relevant to look at what it actually does. It's a very strange piece of drafting. So if we could look please at 554Z11B, this is the gateway to our provisions.
Sorry, which provision are you looking at?
So it's 554Z11B.
Yes,
So
I have. Yeah, I have that. Thank you.
it begins section, I'm going to call it just Z11C, applies if conditions in subsection 2 and 3 are met. First condition is that an overlap. Second condition is that at the time the relevant step is taken, an amount is payable in respect of the earlier tax liability, but that amount has not been paid. So this doesn't apply, just to put that, it gives them that some colour. This doesn't apply if you've already paid the earlier tax liability. So if it's a distribution and you've paid the tax on the distribution, do you satisfy condition 2? No, you don't, because you've paid the liability. That's a puzzle. Don't know why that is. That's what it says. If you satisfy the conditions because you haven't paid the earlier liability, and only if, then we get through the gateway into Z11C. Could we turn over, please? And what this does, we can see in subsections 3, 4, 5, and 6. This essentially says, if you've paid tax in respect of one of the charges, it is treated as paid in respect of the other charge, and vice versa. I think Mr. Ghosh put it essentially those same terms. So it is not disapplying Part 7A, as was, I think, suggested at one point yesterday. It is saying that a payment in respect of one liability is treated as in respect of the other liability.
Yes.
So it doesn't make any structural change 2 Part 7A.
All of that may be true, but in the real world,
Yes.
is someone going to be liable twice for the same tax?
Is someone on the provisions as they were enacted in 2011? Yes, that's my exact point. In fact, my further point.
No,
is
no,
when
no, no, if the 2017 provisions apply.
the 2017 provisions apply, then no, I don't think you would end up with
No,
double.
well, that's the fundamental point that Mr. Ghosh, I think, is making. That insofar as there's a double taxation problem, Parliament has sought to address it, and not only from 2017, but going back to the date when the charging provision itself came into force in 2011.
But my lord, the point I was about to come to, I appreciate I was dwelled on this for some time. This is legislation in 2017. You can't use this to interpret the legislation as it stood in the earlier years. And our decisions, this paragraph 5 of the FTT decision, our decisions all predate this 2017 legislation. So our PAYE and NIC's decisions were taken, I think, in 2016. So the idea that HMRC can rely upon subsequent legislation to say, well, look, you can reach a different interpretation now to the one you would have reached at the time of the decisions, or indeed in the tax years, because of this subsequent legislation. Well, we respectfully reject that. You can't use the subsequent legislation. So that's what I meant when I said as drafted and as enforced in the years with which we're concerned, there is that problem, and that's to be taken into account because it's presumed that Parliament doesn't intend dual taxation. I've shown you Parliament took careful efforts to deal with the dual taxation it thought could arise. Mr. Ghosh repeated his submission that the FTT applied the same test for general earnings in Part 7A. In my respectful submission, that's not a fair reading of what the FTT says at 137. It says it's essentially the same type of analysis, and the Upper Tribunal correctly said, well, that doesn't mean it's the same test. I mean, if it was the same test, why say essentially the same type of analysis? It's clear in my submission when you read it as a whole, and I took you through it in some detail to show you that in relation to general earnings, the FTT directs itself to consider the reasons and background for the payment. That analysis then necessarily forms the basis for applying the test the FTT thought was the correct test for Part 7A. So it's not fair in my submission to say it was playing the same test and the Upper Tribunal correctly reasoned. I have two very quick points on corporation tax. First, there is a difference between the purpose of the scheme and the purpose of the contribution. That's what the FTT was saying. And you've heard the conditional nature of our argument in relation to the purpose. And second, we say it is a finding.
I'm so sorry. I've got to catch up with you, Mr. Firth. Can you just repeat your first submission?
There's a difference between the purpose of the scheme and the purpose of the contribution. So just because it's a purpose of the scheme doesn't mean it's a purpose of the contribution. That's what the FTT is saying. And that's what Scott's Atlantic Management says. Mr. Daly took you to yesterday.
Thank you.
And simply in relation to whether the tax purpose was an end in itself in relation to the contribution, an independent purpose. Our respectful submission on that is that it was a finding of fact. It was a finding of fact as to whether the tax purpose was an independent purpose of that contribution. The fact that the relevance of that finding of fact may be conditional on certain other points of law falling one way or another doesn't detract from the fact that it was a finding of fact based on the evidence, and therefore is only open to challenge on evidence and Bairstow grounds. And you've heard Mr. Blade's submissions on that. Let me just turn my back one moment. I'm reminded of the Investec point.
Yes.
It wouldn't be wise of me to try and deal with that on foot. If the court wants a very short submission on that, I'm afraid I'm going to have to ask respectfully for a very short time to prepare a very short note. But I don't feel comfortable answering on the foot.
Well, I'll discuss with my colleagues whether we do need that. But if we do, how much time are you asking for?
I think you could literally prepare it within a couple of days. It's not going to take very long.
Well, thank you for that indication. We will consider that and, of course, let both sides know if we require anything further in writing.
I'm grateful. My lords, my lady, unless there's any further questions, those are the submissions in reply.
So thank you. Are there any questions? Well, we're very grateful not only to the advocates from whom we've heard, but also their teams, because we're well aware of how much time and effort goes into the preparation of a case such as this. We will reserve our judgments. Drafts will be circulated in due course to those counsel and solicitors whose details were supplied before the hearing, so that they can draw our attention to any typographical or minor factual errors, and to agree a draft order if possible. If that's not possible, we will invite brief written submissions so that an order can be finalised at the same time as hand down. I must stress, in the light of recent judgments of this court, that circulation to the parties or any other person for the purposes identified in the Counsel General for Wales case is the responsibility of solicitors. Any such circulation is for those purposes only, and any other publication may be a contempt of court. Unless there's anything else, that draws this hearing to a close. Thank you.
All eyes in favour?